Today we are going to be doing construction and implied terms, the background of social expectations. So that's the lecture for today. Let me also just say, now I'm becoming a professional YouTuber. Likes are good, comments are good, and of course, smash that subscribe button. This is just going to be amazing. I'm definitely about to launch a career in contract lectures. Okay, so to be serious though, you can always email me, of course. My email is right there. If you're on Twitter, then you can look me up. In the real world, you can even come and see me in my office, but you're always welcome to get in touch. We'll take a break in the middle of this lecture, and I won't go onto Teams then like I did last week because I kind of messed it up with the stream. I'll just do some hang around for questions just after the lecture if anyone wants to go onto Teams. And I sent you the link on the email. Slides are also already up on Keats, so you should be able to find them there. And let me just say again, I think I said it last time, what you should try to do with these lectures, like all lectures, is try to avoid sort of pausing and playing, but just listen through or watch everything through, take notes as fast as you can. But once that's done, just go to the reading. Don't sort of spend like 4 hours going back over the lecture notes. Just focus on the reading. And I think that McKendrick is the good book to read. Here is McKendrick. So that's the other Ewan McSomething. He's a very different person, but excellent book. And of course, Andrew Burrows and Anson is superb too, especially since he's now on the Supreme Court. Okay, so what I'd like to talk about today is the following set of questions. So I think this should be working. And to the first slide. So these are the central questions that we want to grapple with in today's lecture. First of all, what do we do if there is a conflict of interpretations over the meaning of a contract? What do we do if the contract's apparent meaning seems to be unfair, particularly for a party who is lacking in bargaining power, or if what the contract looks like it means at first could compromise important social rights? Third example of what we're looking at today is what happens when the express terms of a contract run out and a contract is silent on an important issue, or even if the express terms contradict people's fair expectations. So last week we focused on the ideas of, or introduced the ideas of freedom and power. And then we looked at express terms and how through signatures and oral exchanges, terms become incorporated into a contract. And then we looked at the sort of notice rules and the course of dealing rules. This part of the course in this lecture is about how we interpret terms and what happens when the express terms that we've interpreted have run out. That's what we call when implied terms come in. Like last week and like all lectures, I would like to make three main arguments over the course of this lecture. So the three main points that I'm going to try and persuade you of today are the following. First, that construction of contracts, like all of the law, should advance social rights and not enable the abuse of power. When we say construction of contracts, what we mean is like building up a contract. In its totality, what does it all mean? So the construction of contracts should advance social rights and not enable the abuse of power. And that when we're looking at the meaning of a contract, there's no such thing as an objective meaning of words, divorced from people's real experiences, because our language is shared, and we ought to be guided in interpreting meaning by our shared values of justice. And I think that goes for contract law, just like statutes, just like the interpretation of any written instrument. But of course, we're focusing on contracts today. The second main point that I want to argue is that we should interpret contract terms coherently with all of the legal framework, all of the law, in light of people's reasonable expectations. And when people's expectations about a contract conflict, we should be guided by commercial sense and by the background of human rights. And the third main point that I want to put forward is that implied terms, so when the express terms of a contract have run out, implied terms should follow commercial sense and rights. And implied terms should, I would argue, displace unfair express terms unless the parties have equal bargaining power. Now, that last point, as you'll see a bit later in the reading, is the most controversial one. So I think it's generally accepted that express terms can't be contradicted by implied terms in commercial contracts. But the really big issue is, well, what happens when you have parties of very unequal bargaining power and you're dealing with, a corporation and a consumer or an employee or a tenant? Okay, so that's going to be the three main points for today. So first of all, I'd like to start with a little bit of a story. And this is the story about construction of contracts. And we're going to go through the ideas of power and its abuse, people's expectations, and the concepts of literal and contextual meaning. So the story I'd like to begin with is one from Lord Denning. And you all know Lord Denning. There he is in his very long wig. But this case, George Mitchell and Finney Lockseeds, was actually Lord Denning's very last decision in the Court of Appeal before he retired as Master of the Rolls. And, at the end of his career, he decided to look back at, one of the issues that had animated much of his practice and much of his work as a judge. So he says the following in this case. None of you nowadays will remember the trouble we had when I was called to the bar, back when he was a young lad, with exemption clauses. They were printed in small print on the back of tickets and order forms and invoices. They were contained in catalogues or timetables. They were held to be binding on any person who took them without objection, and no one ever did object. He never read them or knew what was in them. No matter how unreasonable they were, he was bound. All of this was done in the name of freedom of contract. But the freedom was all on the side of the big concern, which had the use of the printing press. And remember printing press and Samson from last week. No freedom for the little man who took the ticket or order form or invoice. The big concern said, take it or leave it. The little man had no option but to take it. And the big concern could and did exempt itself from liability in its own interest without regard to the little man. It got away with it time after time. When the court said to the big concern, you must put it in clear words, the big concern had no hesitation in doing so. It knew well that the little man would never read the exemption clause or understand them. It was the bleak winter for our law of contract. And it was illustrated, says Lord Denning, by two cases, Thompson and London Midland and Scottish Railway, which, of course, we saw last week, in which there was an exemption from liability, not on the ticket, but only in small print at the back of the timetable, and the company was held not liable when poor old Thompson fell off the railway platform. And Lestrange and Graucop, in which there was a complete exemption in small print at the bottom of the order form, and the company was held not liable. And of course, that's the one that we looked at last week about the dodgy automatic vending machine. And in fact, Lord Denning is saying that this is part of the bleak winter of the law of contract. Tom Denning, when he was a barrister earlier on, was in fact representing F. Graucop Limited. So if you look at the report, it's Mr. Alfred Denning. So on with Lord Denning's opinion and George Mitchell. There was a secret weapon, however. Faced with this abuse of power by the strong against the weak, by the use of the small print of the conditions, the judges did what they could to put a curb upon it. They still had before them the idol, freedom of contract. They still knelt down and worshipped the idol, but they concealed under their cloaks a secret weapon. the true construction of the contract, and they used it to stab the idol in the back. They used this weapon with great skill and ingenuity. They used it so as to put upon them, upon the different contract clauses, a strained and unnatural construction. And this is what we'll see is a bit later is called contra preferentum interpretation. In case after case, they said that the words in the contract were not strong enough to give the big concern exemption from liability, or that in the circumstances the big concern was not entitled to rely on the exemption clause. Whenever the wide words, in their natural meaning, would give rise to an unreasonable result, the judges either rejected them as repugnant to the main purpose of the contract, or else cut them down to size in order to produce a reasonable result. And we'll see more of this judgment next week. But Lord Denning goes on to say that this means it's especially important, the abuse of power by the strong against the weak, and the need to avoid convoluted rules of interpretation. It's even more important that we have laws, by then in statute, but also at common law, to control unfair terms. And Lord Denning had been saying the same thing for a number of years, and he also applied the same reasoning, or very similar reasoning, to the interpretation of statutes, so that we see that in Seaford Courts Estates and Asher, where Lord Denning says that when we're interpreting statutes, we should interpret them in light of the social conditions prevailing, the meaning behind the statutes and the social policy behind them. Okay, but so what we want to know from Lord Denning is, well, if we've got this idea that we should find the natural meaning of a contract, how do we actually get to that? What is the natural meaning of a contract if we don't want a strained and unreasonable construction, and also perhaps if we are concerned about the abuse of power? I think a good starting point for this, and in fact a lot of contract law, is going back to the old Scottish lawyer, Adam Smith, of course, famous as the father of economics, and he had a chair of moral philosophy at Glasgow University. But he lectured in law, and in his famous lectures on justice, police, revenue, and arms in 1673, Smith introduces the lectures by saying that the foundation of a contract is the reasonable expectation, which the person who promises raises in the person to whom he binds himself, of which the satisfaction may be exerted by force. So there's a few ideas there, but the two main ones is that a contract is ultimately an obligation that is enforced by the state, and because the state uses coercive force ultimately to enforce contract through damages, injunctions, and so forth, it should reflect people's reasonable expectations, and this is the foundation of the contract. But then we go, well, where do we get reasonable expectations? If this is the basis of contract, well, where do they come from? And I think there's a few different answers to that. But obviously, it can be true that expectations differ according to people's social context. So people's expectations in commerce are different to people's expectations as consumers, different to employment expectations in tenancies, investment companies. So there's different expectations that people have, reasonable expectations in different fields of life. And I think that this is important from Smith because the same language, as we'll see, has been repeatedly used by our courts. And Lord Steyn, in this article, which you'll also find in the reading, about contract law being to do with the fulfillment of reasonable expectations of honest people, is a very influential one. We'll see that as we get to implied terms. But so, when we're going about looking at people's expectations and looking about the background, I think there's also some more philosophy that we can appeal to that has been very influential throughout the history of contract law. And particularly this passage from Emile Durkheim, The Division of Labour in Society in 1893. And in my bad French accent, because Durkheim was French, he says the following. So he's French. Not everything in a contract is contractual. You see, the French say like the contradiction. An express contract is not sufficient unto itself, but is possible only thanks to the regulation which is originally social. it will frequently be set against the background of usage familiar to all who engage in similar negotiations, and which may be supposed to govern the language of a particular agreement. So what Durkheim is saying here is that even the express terms of a contract don't complete what a contract really means. We have to look at the background of expectations that people have, and that is embedded in what society does and what it thinks. We see very similar ideas coming across in what Lord Wilberforce says in Reardon Smith in the House of Lords in 1976. But then we go, well, what else is it that might determine the background of people's social expectations? And I think one of the big points about people's social expectations has to be, in a democratic society, that power won't be abused, that people have rights, and that's what people often come to expect. And we see this idea of the abuse of power not being or being a legitimate thing that contract law should control in this passage by Otto von Guercke, who's a great German lawyer that taught at the University of Berlin, in The Social Role of Private Law in 1889. And as he's German, I'm going to do my bad German accent. So Guercke says, if the modern legal system introduces the principle of freedom of contract, it can only mean a reasonable freedom, not an arbitrary one. Freedom whose moral purpose requires balance, freedom which itself sets boundaries. Unrestricted freedom of contract destroys itself. A fearsome weapon in the fist of the strong, a blunted tool in the clutch of the weak. It becomes the means of oppression by one of another, the merciless exploitation of the intellectual and economic power. More than ever, it is the task of private law to protect the vulnerable from the strong, the welfare of the whole against the interest of a few. Okay, so that passage I think is very influential in German thinking because it was part of the debates that precluded the German Civil Code, and very influential in how the ideas behind German law developed. And of course, because like French law, German law is very influential across Europe. That has been received in European law and certainly influenced what we do in the UK today. Now, very quickly, you can see that when we start discussions about meaning, they tend to become political. So we start off, the simple idea of what is the meaning of a contract, and we get to the idea of reasonable expectations. And then very quickly, we get into discussions of power and the abuse of power. That is, perhaps a little disconcerting because people might often want to find that there are simple answers and that we can just have a neutral or objective answer. And that engages one of the biggest debates in modern philosophy, and particularly the philosophy of language, going back to Ludwig Wittgenstein in Tractatus Logico-Philosophicus in 1918. Now, Wittgenstein, an Austrian man, had moved to Cambridge in the UK and had worked with someone called Bertrand Russell, another great philosopher. And together, as represented, probably in a little bit easier to read, Russell's article called The Philosophy of Logical Atomism, they both wanted to develop the idea of a different kind of approach to philosophy, because they wanted to end philosophical and political disagreements that had been raging, back for 2,500 years to Plato's time. And so Wittgenstein and Russell argued that language has an underlying logical and objective structure. They contended that you can take any sentence that there is and break it down to its atomical parts, its atomical components. And then you can, once you've disaggregated the meaning of a sentence, no matter how jumbled, no matter how, much disarray there is in any sentence or paragraph or book, that you can take it down to its logical parts and analyze in its elements, in its very little atoms, its true meaning. And this is what we call, or is associated with, philosophical positivism. So for philosophers like Russell and Wittgenstein, this was supposed to have the result that any proposition could be found to be logically true or false. Once you break things down to its underlying logical form, you can say at its barest bones whether something is true or false. And this, they thought, would be the great end that philosophers had searched for since the time of Plato. There could be an end to disagreement, an end to all philosophy, because you could break down the underlying objective meaning of language. Now, the later Wittgenstein spent most of his later career criticizing the earlier Wittgenstein. This idea that there could be an objective meaning behind language was what the younger Wittgenstein said, but the later Wittgenstein said that that was all wrong. And in Wittgenstein's life, I think that there might have been a number of important influences. One was the Second World War. So he writes Philosophical Investigations, his second great book, in 1953, or this comes out, I think posthumously, but after the Second World War, when he's writing. And of course, the Second World War was launched primarily in Europe by Hitler, a crazed little man with a little silly moustache, who actually went to school in Austria with Wittgenstein. And the second thing was, and of course, all of the Nazi propaganda was about the distortion of meaning and about the distortion of words used to victimize vulnerable social groups, the socialists, the trade unionists, the Jews, the disabled people, anybody who had political dissent or wanted to display to political dissent. And I think one of the other influences on Wittgenstein was his experience in leaving Cambridge in the philosophical circles and the high-minded debates that he started when he wrote the Tractatus, and going to teach in primary schools back in Austria, and teaching very small children. He taught mathematics. In looking at the way that they developed their language, shifted Wittgenstein's thinking a great deal. So the later Wittgenstein spent all this time saying that everything that he'd said before was completely wrong. And the key idea was that the meaning of a word doesn't have an objective underlying atomical fact. The meaning of a word is always in its use in the language. So this is the idea of contextual meaning. Meaning doesn't come from objectivity. Meaning comes from context. And words can be interpreted in multiple ways, he says. The true meaning depends on a shared understanding of something, not, like there's an objective answer out there. Language, he says famously, is like a labyrinth of paths. You can approach words or sentences from one side and you know your way about. You approach the same place from another side and you no longer know your way about. That's the idea that the same things can mean different things. The same words can mean different things to different people depending on the context that they are in. Now, we see that even more graphically illustrated. That's all linguistic philosophy, but we see that even more graphically brought to life by the famous book by George Orwell, 1984, as I'm sure many of you will have read. And if you haven't read it, you definitely should. So, as many of you know, Orwell's 1984 is a dystopian novel set in this world of Airstrip 1, which I suppose is meant to be England after a sort of apocalyptic event, perhaps at the end of the Second World War, in a different way. And in this world, there is a functionary called Syme at the Ministry of Truth, and he is engaging in destroying words for a new dictionary that the regime wants to set up, the Newspeak Dictionary. Synonyms and antonyms are all going to go, and this is supposed to leave a perfect simplified language. So the dictatorship is breaking down language to its atomical parts, and this is used for the purpose of party control. They want to eliminate words, anything that is excessive, any extra words. They want to eliminate all the superfluity in order to try and control and preempt any context that people have for opposing the regime. Once you set up a perfect language, they think, stripped to its atomical parts, you can use the language in ways that manipulate people. So the Ministry of Truth is actually the Ministry of Lies and Distortion and Propaganda. The Ministry of Justice is precisely the opposite. It's the Ministry of Oppression. And they have this notion of doublethink, that people, through training, are made to believe contradictory things at the same time. Words become to mean whatever the party wants them to mean, and party members start quacking the arbitrary shifting policy of the regime leader, Big Brother, just like ducks. And I think that's very important for what we are going through today, very sadly, where you have far-right people like Donald Trump who breed, these lies and distortions, saying things like, I won the election, or that was a perfect phone call, or I had the biggest turnout to my inauguration ever. Lies like that, to manipulate people into thinking two things at once, particularly when they can't be true. So language always has a political setting and can be used politically. And in law, it is no less true. So the words that we have in law and the meanings that we attribute to contracts, it's very, very most basic, do have political significance. So now I want to get to how all of this plays out in legal interpretation and how the differences in interpretation or differences in interpretation have developed through the courts from the 19th century up to today. So back in the 19th century, we see examples of something like Russell and Wittgenstein's earlier work, and something like the sort of Newspeak dictionary, judges in the House of Lords saying that there could be a literal meaning that you could find through adjudication. One of the most famous cases is the leading decision in company law called Salomon and A. Salomon. And this is about the interpretation of the Companies Acts of 1862, where it said, we don't need to go into this, but where it said that you need 7 people to set up a company. And you've got Mr. Salomon, who's really a one-person business, but he's got his wife and his children to all subscribe shares. And the question was whether he still gets the protection of the Companies Acts and, most importantly, limited liability when the company goes insolvent, despite having used the Companies Acts in a way that might not necessarily have been intended by the statute. But the House of Lords says that he registered his company in compliance with the registration rules, got 7 people, even if they weren't sort of playing a full part of the business, and therefore he had protection. And you don't need to worry about all the facts. You can enjoy doing company law or enterprise law with me a bit later if you want to. But the key point is the approach in which Lord Halsbury, the Lord Chancellor in particular, says that the Companies Acts and the policy should be arrived at. He says, I have no right to add to the requirements of the statute when he's interpreting it, nor take from the requirements thus enacted. The sole guide must be the statute itself. We are only allowed a literal interpretation. And in another case, a few years later, he says something very similar. The words of a written agreement, or the words of a written instrument, must be construed according to their natural meaning. But what he meant by that was that you take it at face value. It was literal interpretation. Now, that approach, as we will see, has completely changed and is gone in the UK. But if we go over to the United States and we look at the Republican appointees on the US Supreme Court, we still see something very, very similar, and often used in an incredibly abusive way. So one leading example, and there are many, many examples, is a case called the District of Columbia and Heller in 2008, where Justice Scalia, now passed away, argues that what we should do when we're interpreting anything, but he's talking about the US Constitution and Bill of Rights, is look for the normal meaning or the original meaning of the Constitution. And this was a case concerning whether or not a ban on handguns in Washington, D.C. was or was not constitutional. It had been there for 43 years in Washington, D.C. And of course, handguns are particularly dangerous because people can conceal them and they are used in all sorts of awful crimes. And we all know, of course, the appalling problems that the United States has had with mass shootings again and again for a long, long time. Many, many tragic events. But in Heller, Justice Scalia says that in the interpretation of the Second Amendment, which is the right to bear arms, that this ban, which had been there for 43 years, was unconstitutional. And he says that there was nothing in the precedents that forecloses the interpretation, and he says that he's interpreting the meaning of the Constitution, the Second Amendment, by consulting a 1773 edition of Dr. Johnson's dictionary. Dr. Johnson, you'll see a statue of him just near King's on the Strand. He lived nearby. He wrote the first Oxford English Dictionary. This is how Justice Scalia, supposedly by deploying the original meaning, thought it was appropriate to interpret words in the Constitution. And I mean, this, of course, is insane. So through the idea or under the cloak of supposed literal interpretation, Justice Scalia was doing something that completely overturned legislation that had been there for a long time to pursue an open political agenda above the National Rifle Association, the gun lobby groups, the sorts of people that were interested in his appointment as a Republican judge to the US Supreme Court. Because, if we actually did do an original meaning interpretation of the Second Amendment, then we would find that back then, there was no such thing as a modern handgun in the way that we see. Bullets themselves weren't even invented yet. So the right to bear arms in the Second Amendment, meant something completely different back in 1776 or 1787. So what's really going on here under the guise of literal interpretation is a policy judgment, but one which doesn't say that it's a policy judgment. And here are just some statistics on the sorts of consequences that these interpretations by the US Supreme Court Republican appointees have had. An awful results for homicide rates, for suicide rates in the United States. And of course, as the old saying goes, guns don't kill people, people kill people, but guns help a great deal. And, the kind of destructive theories of interpretation have real political significance in many, many ways. Another example is the Citizens United case, also one which Justice Scalia took part in. This is notorious for saying that the First Amendment, right of free speech, apparently speech includes giving as much money if you're a corporation to the political process. So my point is, saying all of this, that under the supposed heading of literal interpretation or finding the objective meaning, what really happens, graphically illustrated by Justice Scalia's jurisprudence, is that people pursue openly political agendas but without being honest about what they are doing. There is no such thing as a literal meaning of language. There are very, very serious policy debates, and that, I think, is what has to be openly and honestly confronted. Okay, so just to round all that off, what I'm trying to say with all of this history and philosophy and politics is these three things. How should we construe contracts or anything written, any written document? Well, I think that the answer should be that we should fulfill the parties' reasonable expectations, including the background of social rights that are at play. And that's true whether it's a contract, a statute, a constitution, or anything else. We should attribute meaning according to what our social values are in the 21st century. And the further we are from human rights, the more doubtful an interpretation ought to be if we do value human rights and justice. And thirdly, we should favour contextual and purposive interpretation. And in the UK, as we're about to see in more detail, we've long abandoned, and rightly so, the dishonesty of so-called literal interpretation. People who say that there's an objective meaning, that there's an original meaning, or there's only one answer, really shouldn't be trusted. Okay, so now we're going to get into the law of the United Kingdom on contracts, and we're going to go through the leading cases, particularly IC Eston West Bromwich, Wood and Capita, and then we're going to talk about what's known as the contra proferentum rule. So this is the leading case, the one that you really need to note and keep in mind. It's called Investors' Compensation Scheme and West Bromwich Building Society. So the facts might seem a little bit obscure, but finance is really easy. It just sort of sounds complicated at first, but it's super simple. So the investor compensation scheme was set up by something called the Securities and Investment Board. That's now a body called the Financial Conduct Authority. And it was set up to compensate people who'd been ripped off by being sold dodgy investment products. These were called home income plans by banks and building societies, one of them being West Bromwich Building Society. So we don't need to go too much into the facts, but basically you had all these consumer investors that had been ripped off with these dodgy financial products. They'd been misinformed, and they had a right to be compensated. So the government watchdog, now the FCA, then the Securities and Investment Board, sets up the Investors' Compensation Scheme to compensate people for their losses. Okay? But then what happens, and the bit that we're concerned with, is that the Investors' Compensation Scheme gave money to those customers. So, all the consumers, the investors, they're kind of done, they've been compensated. And in return for the compensation, the consumers had to assign their legal claims against the different banks and building societies to the Investors' Compensation Scheme. Okay? And you see the reason why this is being done is because it's a lot easier for one Investors' Compensation Scheme to pursue claims, legal claims against the banks and the building societies than all of the different consumers suing by themselves. So it's the collectivization of legal rights. And in order to do this, in order to make it work, the customers have to assign their legal claims to the Investors' Compensation Scheme for misrepresentation or whatever other kind of wrong there is. Now, this depended on the contract. So what was going wrong in the contract? Because, this is a case between the Investors' Compensation Scheme and one of the building societies that's trying to get out of being sued for the dodgy investment products. So the investment contract said the following. In section 3B, and here we've got to read a bit carefully, it says, any claim, whether sounding in rescission for undue influence or otherwise, that you, that's the customer, may have against the West Bromwich Building Society is excluded from the assignment. And that means not being transferred to the Investors' Compensation Scheme. So just have a think about what that means. It's saying they're assigning all claims to the Investors' Compensation Scheme except for, and here we quote, any claim, whether sounding in rescission for undue influence or otherwise, that you may have against the West Bromwich Building Society. And I don't know if anyone can type quickly in the chat. Can anyone see what is wrong with this? If they're excluding the assignment of what it says here in section 3B, what could be the problem? It's not necessarily about assigning their legal rights to somebody else, but didn't mention the damages. Good guess. It's not just that. But if we're assigning everything except for any claim, it means that you're not signing anything at all, right? So they're assigning everything except for any claim, whether sounding in rescission for undue influence or otherwise. That's right. So Genghis Khan has said you can't claim. That's absolutely true. So it had gone completely wrong. Exactly. So the House of Lords held, this is what was obviously ridiculous. So the House of Lords held that what they really meant to do in the contract was to assign all claims except for any claim sounding in rescission, whether for undue influence or otherwise, you see? So they wanted to assign all claims in damages, but not claims in rescission, whether for undue influence and otherwise. In other words, the House of Lords said that they got the bracket and the whether in the wrong place. And the House of Lords said that it could be interpreted not according to its literal meaning, because if you did it according to its literal meaning, the Investors' Compensation Scheme can't operate against West Bromwich Building Society. But they could interpret the contract according to its context to make it make sense. And Lord Hoffman, in an important judgment, lists 5 principles about how you go about doing this. In short, in a nutshell, he says that you construe words according to what a reasonable person would understand the contract to mean in the context. But you should, he says, exclude evidence of prior negotiations. So here's the 5 principles that Lord Hoffman sets out. And, you don't really need to get bogged down in, mechanically remembering all 5 principles. But, these are important general guides, very important in commercial practice for how we go about interpreting contracts. So he says, number 1, you should interpret a contract or construe a contract according to what the reasonable person with all background knowledge would think is the meaning of the contract. Second, you should look at the matrix of fact surrounding the contract, and that's anything that could affect the meaning of the language being used. Third, he says, and we'll come back to this, you should exclude evidence of prior negotiations. He says primarily to avoid excessive costs by trawling through lots of documents. Fourth, he said it's not the literal meaning of a sentence that matters. So completely different from Salomon and Salomon and Lord Halsbury, but it's the contextual meaning that we should prefer. So again, not like Justice Scalia, the UK House of Lords and the Supreme Court say that it's the context that matters, and that's the most important part. And fifthly, there's a presumption that people don't really mean to make linguistic mistakes, but sometimes they do. Okay, so those are the 5 principles, and they've been applied many, many times ever since. It's one of the most quoted or cited cases in English contract law. But just to give you another example, here is another case in the Supreme Court more recently called Wood and Capita Insurance Services. So in this case, you had a clause which is a bit long. What we've got to do when you see a very long clause or passage is just have to hone in on the important parts. And in a nutshell, this says, in the contract between Mr. Wood and Capita Insurance after the sale of shares, that the sellers, and that's Mr. Wood, undertakes to pay the buyers or indemnify the buyer against all actions, damages, and or fines imposed on or required to be made by the company arising out of claims or complaints registered with the Financial Services Authority. So again, that's like the Financial Conduct Authority or the SIB before, that's the financial regulator. So the sellers undertake to indemnify the buyer against all actions, damages, and all fines imposed upon the company or imposed upon or required to be made by the company arising out of claims or complaints registered with the regulator pertaining to any mis-selling, da-da-da-da-da. And the rest is blah, 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 blah. Okay, so what happened here was that after Capita bought shares in a company called Short Term, this is an insurance company, so there was a sale of shares in Short Term by Mr. Wood to Capita. The buyer, Capita, found that the short-term staff, the employees, had in fact been misleading customers in a way that broke the law. And of course, this is a financial regulatory problem. So what Capita did, quite honestly, I must say, is it reported itself as having previously been engaged in mis-selling. And then it went to Wood and it claimed the benefit of the indemnity clause. So it was Mr. Wood's fault, really, because he was the owner of the company before that this had happened. But the sellers aren't claiming an indemnity because somebody else sues them. They have reported themselves to the Financial Services Authority and claiming the indemnity. So were they allowed to do this? Could the contract be interpreted to cover this? And basically the Supreme Court says no, and it says they wouldn't make commercial sense. And I think that we can actually argue about whether that was a good judgment, whether it promotes good faith, whether it promotes honesty. But the important thing is the principle behind it, which is that Mr. Wood did have to, the question is, did Mr. Wood have to indemnify? They say no, but the reason is that it wouldn't be consistent, says the Supreme Court, that it wouldn't be consistent for this interpretation with common business sense or business common sense. So the way that we should interpret commercial contract should, as a starting point, be consistent with what makes commercial sense. We see these statements being made a number of times in a number of other cases, Rainy Sky and Coopin Bank, where there's two or more possible interpretations of a contract. We should choose the one that matches the commercial purpose of the deal. So I think that is relatively uncontroversial. You choose the meaning that makes most sense. Okay, now then we've had a little bit of debate about this idea of Lord Hoffman that you shouldn't look into pre-contractual negotiations. And that came up again in a decision called Chartbrook and Persimmon Homes. What happened here is that Persimmon was, a big home developer, and it had a deal to build on Chartbrook's land, and then after it's built the properties, it's going to sell them, and it would give Chartbrook 23.4% of the price. This is according to the contract, achieved for each residential unit in excess of the minimum guaranteed residential unit value, less the costs and incentives. And there's a bunch of other stuff in the contract, but when you calculated that literally, it was apparent that there had been a mistake, a very big mistake. Chartbrook argued that it was, the amount owing was £4.4 million, and Persimmon argued that the amount owing, 23.4%, etc., was only £897,000. So a very big difference. Now, if you looked at the pre-contractual negotiations, it was very obvious that the £897,000 figure was the correct one. But the question was, that wasn't in the contract. It wasn't clear from the contract. Something had obviously gone wrong. So were the pre-contractual negotiations admissible as evidence? The answer that Lord Hoffman gives is no. So unsurprisingly, he's sticking with, his points in ICS and West Bromwich. He says that you shouldn't look at pre-contractual negotiations, but you can get to the result, the one that makes commercial sense, the £897,000, by just construing the contract in its context, because they never would have entered into this deal if the contract hadn't potentially been profitable. And so it was very clear that 4.4 million was too much and 897 was the right amount. And according to Lord Hoffman, there's no amount of red ink that you can't use to correct inconsistencies or contradictions in the drafting of a contract. And of course, that's particularly true in construction contracts. You've got these big, long documents. There's loads of stuff in there. The solicitors are often writing them under a lot of time pressure. Sometimes things go wrong. So Lord Hoffman is saying that in interpretation, we can use red ink, sort of like the red hand rule from last lecture. You've got a red ink rule from this lecture. We can use red ink to correct the contract to make it make commercial sense, to match the commercial purpose. So he says we don't need to look at pre-contractual negotiations. Lady Hales takes a slightly different view in the case. She says, well, that's all well and good, Lord Hoffman, but, it made it a lot easier, really, didn't it, that we did know what the pre-contractual negotiations actually said. It was a lot clearer after that. And so maybe we shouldn't be so, exclusionary or rigid about excluding pre-contractual negotiations. But Lord Hoffman is adamant, and he gives some policy reasons why. The first, and I suppose main one, is that there has been rising costs of litigation and in giving advice, and so the more documentary material that solicitors have to look through to find the meaning of the contract, the higher the costs are probably going to be. We are different in the UK, says Lord Hoffman, to countries like France. They start from contractual theory of finding the parties' true intentions, often subjective intentions, and then limit those intentions according to policies on fairness of contracts. But we can't transplant that continental philosophy, says Lord Hoffman, which is debatable, to England, because we apparently interpret contracts objectively. And supposedly this means that we shouldn't go into what people intended from pre-contractual negotiations. And to sum up, he says that this is in the more general interest of economy and predictability in obtaining advice and in adjudicating disputes. So no pre-contractual negotiations go into interpreting what a contract means. Unfortunately for Lord Hoffman, while the rest of ICS and West Bromwich definitely still is good law, other people weren't so sure. Particularly Lord Nichols in this article in the Law Quarterly Review in 2005, he points out that very often we do take into account pre-contractual negotiations, for instance, in actions for rectification of written agreements. That's a procedure by which you say that the written deal wrongly recorded the contract. But then a little bit later, I think after Lord Hoffman was off the bench, in ocean bulk shipping, the Supreme Court says, well, actually, you can have regard to pre-contractual negotiations if, and only if, they are part of the relevant matrix of fact, or the relevant factual matrix. And so then you've got to question, well, what counts as the factual matrix? But I think the point is that if it's relevant to the interpretation of the contract, pre-contractual negotiations can be admissible if it's part of the factual matrix of the deal. Okay, so those are the basic rules on interpretation of contracts. We interpret them in their context, and we try to find what the reasonable person would think a contract means. But we've also got another rule, which is particularly important when we're looking at unfair contract terms. And this is what we call contra proferentum. What this means is that we can construe a contract against the person relying upon a particular meaning, or against, contra, the person who's professing, proferentum, professing a certain meaning of a contract. And what this rule means is that we interpret contracts against the proponent, especially when it comes to unfair or exclusion clauses. This, I think, is not a rule that is confined to contract law. Again, we see very similar things when we're interpreting any part of the law, particularly statutes, because if statutes contain exceptions to a general rule, it's generally accepted that we should interpret exceptions to a general rule in a much more restrictive way. And you will see this in a leading EU law case, which I expect will be in your reading, called Pfeiffer and Deutsches Rotes Kreuz. And that was about an opt-out for the 48-hour working week. So everybody has a fundamental social right to not work really long hours so that you don't get sick and tired from being overworked, limit of a 48-hour week, unless you opt out through an individual agreement. So the opt-out is the exception to this general rule that working time should not be excessive. And in Pfeiffer, the Court of Justice of the European Union says that we construe when you can opt out very narrowly in order to give effect to the general principle, which is the importance of social rights, of limitation of working time. So that meant that people couldn't opt out of the 48-hour week through a collective agreement. They could only opt out through an individual form, as indeed our own statutory framework says. So we see this idea also in some very famous literature. It might not entirely make sense at first what contra proferentum means, but I expect all of you know William Shakespeare and The Merchant of Venice. And in a famous passage in The Merchant of Venice, Shylock, who is the villain of the play, has made a deal with Antonio, who's the merchant of Venice, that if a shipping contract doesn't work out, then in return for a loan, Shylock gets to take a pound of flesh from Antonio. So Shylock says, if you do not repay me on such a day in such a place, such sums, or such sum or sums as are expressed in the condition, let the forfeit be nominated for an equal pound of your fair flesh to be taken, to be cut off and taken in what part of your body pleaseth me. And then Antonio, desperate for a loan, says, I'll seal to such. So a few of you might know the play. And here we've got definitely what seems like a pretty unfair contract term. So if Antonio doesn't pay back the money, Shylock gets to take a pound of flesh. And I wonder if anybody in the chat might know what the answer is, how we could interpret this contract against the person proposing it to make sure that it isn't, or that the outcome isn't too unfair. How could we interpret the contract term of Shylock cutting off a pound of flesh in a way that doesn't lead to Antonio actually dying? Any ideas, or anyone seen the play before? I've got my copy of the complete works of Shakespeare, and I'll let you know that the answer is in Act 4, and I think it's right at the end of Act 4. Any ideas? Well, the answer is that Shakespeare gives in the trial. The flesh could be an animal. Oh, well, that's very inventive. We've got some good lawyers here on the chat saying that the flesh could be of an animal. No, but the contract does seem to say an equal pound of your fair flesh, from Antonio. How could you construe that in a way that doesn't let Shylock actually kill Antonio? And the answer is, when this goes to trial in Venice, so Portia, who's acting as the judge, says, okay, prepare thee to cut off the flesh. But, she says, and as Shylock is getting his knife ready, shed thou no blood, nor cut thou less nor more, but just a pound of flesh. So the court in Venice says, well, you can have a pound of flesh according to the contract, but it doesn't say anything about shedding blood, and you have to take exactly 1 pound. Any more, any less, then you're in trouble, and it's you who's going to be it's you who's going to be prosecuted under the law. So that is a famous example from Shakespeare of contra proferentum. Now we see that in UK law and in Privy Council, coming out in a few cases, but leading one is called Canada Steamship Lines and the Crown. So in this decision, Canada Steamship Lines stored goods in the Crown's shed on the wharf of Montreal Harbour. But, of course, something went wrong. An employee, while repairing the shed with an oxyacetylene torch, so that's one of these things that goes and, it burns with a big flame, and, you can repair stuff, accidentally started a fire and burnt down the shed. The Crown had a strict duty to keep the shed in repair under the Quebec Civil Code, Article 1614, but also Clause 7 of the contract said the lessee shall not have any claim for damage to goods being in the said shed. So the question was, did this clause cover the employee's negligence? And the answer that the Privy Council advises is no. It was interpreted, this clause, to not cover negligence, despite the wide words, because, says the Privy Council, construing contra proferentum, this clause should be construed to cover only, exemptions from liability, regarding liability for its strict duty to keep the shed in repair, but you wouldn't expect that it would also cover an employee's own negligence. What you have to do is put that expressly in the contract, and if you don't, then the courts are going to construe the contract term against you. So we see that in other cases on basically what were all unfair terms, right up to the Unfair Contract Terms Act that we will do next week. We saw last week this case, and we'll just go into it again, called Hollier and Rambler Motors. So Hollier and Rambler Motors was about Mr. Hollier taking a car for repair at Rambler Motors garage, as he'd done 3 or 4 times in the last 5 years. And as we saw last week, there was one issue, which was whether he had signed whether an invoice was incorporated into the deal, which he'd signed before, but he didn't sign this time. And it said the company is not responsible for damage caused by fire to customers' cars on the premises. As bad luck would have it, there was a fire, the garage and the car burnt down, and that fire was caused by faulty wiring, which is probably due to the negligence of one of the employees. So the decision of the Court of Appeal asked, is this clause incorporated? As we saw last week, the answer is no, because there wasn't a sufficiently regular and consistent course of dealing. But the Court of Appeal also says that even if the clause were incorporated, a reasonable person wouldn't think that it covers the garage's own negligence. It should be interpreted contra proferentum, so that only acts of God are covered, not the employee's negligence. Lord Justice Salmon says, I don't think that the defendant should be allowed to shelter behind the language which might lull the customer into a false sense of security. So that's a really hostile interpretation to what is otherwise an unfair contract term. But then you might ask, well, why not just say unfair contract terms are not effective at common law? Another decision of the House of Lords in 1981 says something a little bit more lenient, that courts should be more lenient when it comes to limitation as opposed to full exclusion clauses. But the big issue is, well, why didn't we just say that unfair terms are not binding? Lord Denning tried to. Here's Lord Denning, the crusader for the little man. Again, he develops this idea through a number of cases called fundamental breach. So he says that if a contract is breached in a way which is fundamental, so that it undermines the very purpose of the contract, then exclusion clauses cease to be effective in their entirety, and courts can substitute fair terms. However, despite a number of decisions where he put this idea forward, the House of Lords rejects it. And so you can't get rid of exclusion clauses and therefore control unfair terms at common law. And it says this in Photo Productions and Securicor Transport in 1980. This involves Mr. Musgrove. It's another fire. And Mr. Musgrove is very cold. I suppose it's a bit like now in the winter. He starts a fire in Photo Productions building in order to keep warm. What he's meant to be doing is he's meant to be, the security guard looking after the building. But when he starts the fire, unsurprisingly, inside a building, the building catches fire and it burns down. So Securicor's contract with Photo Productions says that it wouldn't be responsible for any injurious act or default by any employee. Did this exclusion clause cover what Mr. Musgrove did, and did it cover liability, exempt liability for the burnt down building? And this was very sizable damages were being claimed for about £615,000. The House of Lords held that even though the breach was a fundamental one, you're meant to guard the building, but instead you burn it down, the exclusion clause covered liability, so no £615,000 is owing. So there's a rejection that at common law you can control unfair contract terms, either outright or for fundamental breach. On the other hand, in 2003, the House of Lords does sort of backtrack from, full idea of freedom of contract at common law, because it says there can never be exclusion of liability on public policy grounds for fraud. But the question I think that we've got to ask is, well, why is it that if we admit that you can control unfair contract terms on the basis of public policy for fraud, why not for every other kind of unfair term? Why can't the common law go further? And why do we need to leave it all up to statute? Which, of course, we will do more about next week. Okay, so next we're going to go on to implied terms, but first I think we all need a break. So let's take 5. Okay, round 2. Lights, camera, action. So now we're going to talk about implied terms. So remember at the beginning I said that what we did last week was express terms and incorporation, but implied terms are mainly about the question of what happens when the express terms run out. But also there is a very important debate, and probably one of the most controversial things in this lecture, about what happens when the express terms contradict what would otherwise be implied terms in a contract. And that is particularly important when we're looking at relationships where there is unequal power between the parties. So we're going to look at a question of why we implied terms. Then we're going to go through what we call standardized or in-law implied terms, individualized implied terms, or terms known as terms that are terms implied in fact, and then finally the concept of good faith, which has become an increasing part of the debate in English law. Okay, so the first thing is, when might contract terms become implied? Uh, excuse me. I think there's three main points to say about this. So the first thing is that it's pretty uncontroversial that we imply terms into a contract if a contract is silent on an unexpected event. It's uncontroversial, but judges can disagree on the facts about what should be right. There's always some kind of default rule. So it's not like, contrary to the way that people sometimes talk about the way that free markets operate, it's not like there's, a sort of regulation-free zone. The law is always setting some kind of default, for instance, whether goods have to be of satisfactory quality, or they can be of zero quality, or that the loss might lie where it falls when there's an accident, or that one party has to compensate another. But whichever choice a court makes, there is always a default rule. So it's not like the courts can ever, either make a choice or not make a choice at all. Not making a choice is in fact making a choice. So uncontroversial, however, that we imply terms where an important thing is not covered in the contract. Second situation in which we imply terms is and where it becomes very important, is where a contract term gives wide discretionary power to one party, and this could affect the rights of the other party. And in that kind of situation, a court can hold that the discretion has to be exercised um, as necessary, or only as necessary, in a way that would not defeat the party's reasonable expectations. And we see a number of decisions where this is mainly accepted, particularly equitable life, that will come up soon. Third situation where we imply terms is where a contract does appear to make provision for something, but the outcome might defeat the rights or reasonable expectations of the parties. So the court construes the express terms to mean something that it might not otherwise mean when there's potentially conflicting interpretations. And that is the point at which there is most dispute, most disagreement, but hopefully we can try and resolve some of it as we go through. We see that coming out in Johnson Belize and a new case, or a case a few years ago called BNP Paribas. So first thing is about standardized implied terms. And I want to take you on a spaceship ride now around what I call the contractual solar system, because although we've got the sort of general law of contracts, there are lots of specific contracts. And I like to think of this as something like a sun and different planets rotating around. So just like our own solar system, we've got in the law of contract, the general rules that we see for offer and acceptance, consideration, intention to create legal relations, no misrep, no undue influence, no duress, and frustration and common mistake will avoid a contract unless you've got a properly drafted force majeure clause. So those are the sort of general rules and the general law of contract. But then in lots of situations, we have specific contracts, like planets rotating around the sun. So we have different rules and different implied terms for credit agreements, for leases, labor law, employment contracts, consumer contracts, companies, franchises, agencies, commercial sales, insurance. I think this is similar to the same thing as I showed you last week, but this is particularly important when it comes to implied terms, because you see on those planets different default rules applying to each, simply because the subject matter is different. So, an easy example is in employment, one thing that is exchanged is work, and another thing that is exchanged is a wage. Work for a wage tells you that you've got a work contract, and if there's unequal bargaining power and control and various other things, then you say that it's an employment contract. Different, of course, to a commercial sale where there's no work being exchanged. So that's a really simple example, but basic point is that there are different implied terms on each planet. So first of all, I'll take our contractual spaceship to planet sales and see that in the Sale of Goods Act of 1979, there are some very important implied terms for the sale of goods. So in section 12, for example, it's an implied term that the seller has title to the goods. So if you're selling something, and also think back to those mistake about identity cases, then you have the implied term that the person selling does actually own the thing that they are meant to sell. And somebody's just asked, terms can be implied equally in oral as in written contracts. Is that right? And yes, absolutely. We have implied terms whether a contract is written or not. In fact, there's very, very few contracts where writing is a requirement. Sale of land is the primary one, but in most contracts, there's no formal requirements. Okay, so a bit more about the Sale of Goods Act. Section 13 says that if you have a description of goods or goods being sold by description, the goods very simply have to correspond to the description. And under Section 15, if there's a sample, then the goods have to correspond to the sample. Practically most important is Section 14, subsection 2. And that says that businesses selling goods have to sell goods that are of satisfactory quality. It used to be called merchantable quality, but this is really important because, if you buy a pen or if you buy a phone or something else, then it shouldn't break down. It should be of satisfactory quality. And then in 2b, it goes on to say that this also means in terms of the appearance, the safety, and the durability of the good. Now, all of these implied terms have very big consequences. I don't want to suggest that these are, yes, I think that they are what people would expect, but there are politically meaningful choices being made. And I think that that's very important with the climate crisis that we've got at the moment and the problems of the environment related to Section 14.2. Because Section 14.2 tells us that goods have to be of satisfactory quality, but that's not a particularly high standard, right? It's good, it's better than nothing. But if you have your washing machine breaking down, or your laptop not working, or expiring after sort of 4 years or 2 years, just after the warranty expires, this means that a lot more things are created. Things are built that aren't made to last, and the sheer volume of materials being used for various products would be different if we had higher standards for the type of quality that could be expected. But nevertheless, there we are in Section 14.2. There's a right to satisfactory quality. In commercial contracts, you can opt out of that, but as we will see in the next week and the week after, it has to be reasonable, generally between small businesses and big businesses, and it becomes compulsory in the case of consumer contracts. Similar thing in the Supply of Goods and Services Act of 1982. So Section 13 says that when you're providing a service, you've got a duty of reasonable care and skill. Section 14 says that you have to perform within a reasonable time. So if there's nothing in the contract about, when I'm going to, do some writing for you or do a lecture for you, if you're paying me, oh, that would be fun, wouldn't it? Then I would have to perform in a reasonable time. And even if you don't specify the price, Section 15 comes in. It doesn't say that the whole contract is void for uncertainty. No, we don't do that. We say that a reasonable charge has to be paid. So those are just some examples in sales of goods and services about the implication of terms through statute. And I noticed it on the last slide, but I'll just say it again explicitly. All of these terms were generated at common law before they got codified into statute. So it's not like statute is completely divorced from common law. It's not. Often statute does what already has been or has become the practice at common law or in principles of equity. So back in our spaceship, and let's go now to planet companies. There we see, and you do this in company law, a huge array of standard or default rights set down in the company's model articles regulations of 2008. So if you want to go and register a limited company, say you want to set up Pens Limited, or you want to do an initial public offering and have Pens PLC, then you're going to need a company constitution. But if you don't want to write your own, don't have time, it's going to take a lot of cost, you don't really feel like consulting a lawyer, then you can just rely on the default constitution that the legislation gives you. We don't, however, have legislation for all different contract types. Goods are good. There's a relatively developed system of implied terms for goods, very developed system for companies, but as we will see in other contracts, there's not yet. So now we go to planet leases and one of our leading cases on implied terms. This is called Liverpool City Council and Irwin, and it involves a very rundown council estate in the 1970s, which was so bad that it became known as the Piggeries, an old Liverpool council block that was meant to be maintained by Liverpool City Council. But it had got very dirty, it had become vandalised, and as a result, the tenants who lived there were going on rent strike. So they were refusing to pay the rent because they said, well, look, our landlord is treating us so badly, we shouldn't have to pay. Now, in response to the rent strike, the council tried to evict the tenants. So what they did is they counterclaimed for breach of contract. There wasn't anything in the contract explicitly. In fact, many of them didn't even have written contracts. And so nothing in the contract explicitly that said that the landlord had to do adequate repairs or keep the building fit for human habitation. So the question was whether there was an implied term. Express terms run out, implied terms come in. And was there an implied term that the landlord had to keep the block in repair? And the Court of Appeal held that there was, but that the tenants lost anyway. Now, that's not so important. Well, a little bit important, but the important thing is why. So Lord Denning in the Court of Appeal, Master of the Rolls, says that there's a duty on the landlords to do reasonable repairs. And this term could be implied whenever it's reasonable, based on, he says, stacks of cases, and he cites authority saying that we should imply terms when it's reasonable to do so. But he says on the facts, the duty, although we've implied a duty, the duty is not breached because the tenants should have done more themselves to keep the place clean. It wasn't the landlord's fault that it was in such a state. Now, he was dissenting in that judgment in the Court of Appeal, and in his result, he was upheld by the House of Lords. But in his reasoning, he was not. So the House of Lords says, yes, we agree that there should be a term implied, that the landlord has to keep the place in repair. But we only imply terms, says Lord Wilberforce for the majority, we only imply terms when it's necessary to do so. Now, one of the big problems with this judgment, and most of the discussion, as we're going to see throughout the other cases, is that judges often don't say necessary for what purpose. But the test is pretty clear, on the other hand, that we don't imply terms whenever you want to, Lord Denning. We don't imply terms whenever Lord Denning or the courts think it's reasonable to do so. It's more restrictive. It's a necessity test. As I say, the House of Lords ultimately upholds Lord Denning on the result, that the term existed but wasn't breached. But the important thing for our purposes now is that we imply terms when they're necessary. And as we'll see, we do it according to later courts for a particular purpose, and that's the party's reasonable expectations. But now on to a few more planets before we get into that. In Planet Franchises and Shell and Lostock Garage, we see the Court of Appeal being faced with a claim by Lostock that Shell breached an implied duty to it as a franchisee to not discriminate against Lostock when Lostock was being sold petrol under an exclusive supply agreement. So Lostock was losing lots of money because it had to buy from Shell, and the price from Shell was going very high. And it was particularly annoyed because Shell was selling petrol at lower prices to other parties. So Lostock was saying, well, it should be an implied term that you can't discriminate against me. It switched supplier, terminated the contract, Shell sued for damages. Was there this implied term? Lord Denning held no. It wasn't a common enough term to be implied in law, and there was no implied term on facts. But so there we go. Lord Denning is applying, saying that there's not this implied term, non-discrimination in Planet Franchise. Main point here is different kinds of implied terms in different kinds of contractual context. Now we go to Planet Labour, and one of my favourite cases, which is called Dr. Johnson and Bloomsbury Health Authority in 1991. So this is a very sad case in many ways. Dr. Johnson's contract was with UCL, University College London Hospital, and it said that he should work 40 hours a week, but that he could have to do overtime of an extra 48 hours on average, right? So 40 hours, but then he's got a contract term that says he could have to do overtime up to an extra 48 hours on average. And sometimes he was going even further than that average. Sometimes he was doing 100 hours per week, like 168 total. And the case report said, and I quote, Dr. Johnson suffers from stress and depression. He is lethargic and his appetite and ability to sleep are diminished. He has been physically sick on occasions from exhaustion and has felt desperate and suicidal. And that was just from working at UCL. And so think about, on top of that, all of this extra work and overtime that he has to do. So he is in a very bad way. And so what he does, the serious point, is that he sues for a breach of implied term because he says that there should be a safe system of work. Okay, now all of the Court of Appeal in this case found in Dr. Johnson's favour under the Unfair Contract Terms Act of Section 2.1. We saw that last week. We'll see it again next week, which is that you can't exclude liability for death or, in Dr. Johnson's case, personal injury. But they differed on whether there should be an implied term of the safe system for the safe system of work. Because you've got this express term that says that he's able to, that the employer can ask him to work on average 48 hours overtime. So 3 different judges, 3 different positions. First position, Lord Justice Stuart Smith held that the implied term, that's the duty to provide a safe system of work, overrode the express term of the contract that gave UCL Hospital the power to require that he works 48 hours overtime on average. So the express term, the safe system of work, cancels the implied term cancels the express term on overtime to protect Dr. Johnson's health and safety. The second judge, Lord Justice Brown Wilkinson, sort of takes a different position, and a more nuanced position. He held that the express term had to be exercised in light of the implied term. So the discretion about asking somebody to work overtime 48 hours could only be exercised in light of the implied duty to provide a safe system of work. And discretion, the use of a discretionary power, could not be abused. So that meant that Bloomsbury Health Authority was in breach of contract. The third position, and I think that the least palatable position, is of Lord Justice Leggett. He says that the express term overrode the implied term. So, the contract terms trump Dr. Johnson's right to a safe system of work. And so the only reason that Dr. Johnson wins is because of the statutory duty and the prohibition on excluding liability for death or personal injury. So position number 1, implied terms override express terms, and particularly when you've got an important social right. Position number 2, you have to exercise discretionary express terms in light of implied terms. Yeah? So that's Lord Justice Brown Wilkinson. Position number 3, Lord Justice Leggett, express terms override implied terms. So a majority is saying that we should at least cut down the express term, but Lord Justice Stuart Smith and Lord Justice Brown Wilkinson differ on how you actually go about that. Now, we see more of this idea of implied terms and duties to employees on Planet Labour in Scully and Southern Health and Social Services Board. This is really all about an extra duty that employers have to inform their staff about important rights that they have, here concerning a pension. So here Dr. Scally and others were claiming that the Southern Health and Social Services Board hadn't properly told them about certain pension rights that they had, meaning that they were out of time to claim pension benefits, which would have meant a significant amount of money in retirement that they would have been entitled to. And of course, you can't claim extra pension rights if you don't know that they exist. And so the employees, the staff, were claiming that there was implied duty to inform them about their rights. Lord Bridge holds that there is a term that requires the employer to inform their staff about their rights based on what is necessary to fill the staff's expectation of legal rights. And just another example, because it's important in practice, of an implied term on Planet Labour comes from Malik and BCCI, which is that in every employment relationship there is an implied term of good faith, also known as mutual trust and confidence, which means that employers have to show respect, treat employees and their staff with dignity, and employees owe the same relationship of trust and confidence as well. So what is it that gives rise to the implied terms that we see in these different categories of contract? Elizabeth Pedden, in this article in the Law Quarterly Review, I think sums up what is probably generally accepted, which is that these implied terms reflect a policy position. They are default rules that reflect what people think is right for these types of contracts. She says, the essence of the test is a consideration of the nature of the contract and of how to maximize the social utility of the relationship. So this isn't just sort of about what, guessing what the parties would have intended. It's about how to maximize the social utility of the relationship. You should take into account, she says, the existing law, the legislation, the nature of the parties' relationship, fairness, and the broader effect on society. That is what should guide the implication of terms in specific contracts outside of the general law of contract. But it would be good, she says, if there were more openness that would allow judges to feel less that they were simply creating the law and more that they were ensuring the continuity of the common law's development. So she's saying, be open about why you're implying terms. Don't hide behind obscure tests. Say what the policy conflicts are and the policy decisions are. That's the best way to reason. Okay, so now we're going to go into detail in cases where we don't have standardized implied terms, a sort of pre-existing set of default rules. And we look at what we call individualized implied terms. So not the standard standard terms that you find in different categories of relationship, but individualized to the particular context of a party's or two or more parties' contracts. These are also known as terms implied in fact, as opposed to terms implied in law. And as I say, they come in when there's no ready-to-hand precedent for a previous default rule. So the way that we go about implying these kinds of terms is up for a lot of debate. Now, the leading case in the 19th century, and one that is still cited very much today, particularly in commercial contracts, is called the Moorcock in 1889. So this was about a ship called the Moorcock, which was unloading cargo at a wharf in the Thames, but unfortunately as the boat came along it hit some rocks and the underneath of the boat was damaged by the rocks. So the ship owner isn't very happy about this. The ship owner sues the wharf business, arguing that they should know that there was submerged rocks as the ship was coming into shore. It should have known the risks and it should have done something about it. So they should be liable for damages for breach of contract. It's saying there's an implied term, and that implied term was breached. And it's an implied term arguably because the contract doesn't say anything about this situation. The parties just hadn't written anything down. So what do? The answer, says Lord Justice Bowen, is that the court should place liability in a way that gives such business efficacy as must have been intended. But then you go, well, what did the parties intend? If you had asked before the contract was signed, or after the contract is signed, before the ship has hit the rocks, who should be liable? Good chance is that both parties intended different things and they wouldn't agree. The Court of Appeal, however, holds that, upholding the court below, that the wharf owner is liable. And it says that the reason it's doing this is that the place of liability must have been in the contemplation of both parties. Now, that's a very easy test to state. We sort of think up hypothetically, what the parties might have intended, what might have been in the contemplation of the parties. But the reality is that often people intend and contemplate very different things and they disagree, and that's why they litigate. So this test doesn't necessarily get us very far. Obviously, business efficacy is a nice idea, but it doesn't give us clear guidance. And indeed, in 2009, in a case called The Reborn, very similar facts and the opposite outcome. Okay, so how did the test develop over the 20th century and early 21st century? The next main case that everyone talks about still is called Southern Foundries Limited and Sherlaw in 1939 in the Court of Appeal before going up to the House of Lords. So this is actually a company law case about Mr. Sherlaw, who was hired as a managing director on a really cool luxury contract with all the frills. It said that he was going to be a managing director for 10 years with a pretty substantial salary. But then you had the company Southern Foundries being taken over by new shareholders. The new shareholders weren't as delighted with Mr. Sherlaw as managing director as the previous owners, so they changed the company's constitution and dismissed Mr. Sherlaw from the board. So the question was twofold. If you do company law, there is a question both about whether he gets damages and whether he can remain on the board. And for our purposes, the important point is whether there was an implied term that he can remain on the board. Was that a part of the contract? It is held, by the way, that he certainly gets damages for breach of contract. That's not really controversial, but ultimately it's held by the House of Lords that he can't remain on the board. And the important thing for us is, what is the test about implied terms? So House of Lords holds that there's no right to remain on the board. The Court of Appeal lays down a famous test, or Lord Justice Mackinnon, as follows, known as the officious bystander. Lord Justice Mackinnon says, when we're implying terms, if I may quote from an essay which I wrote some years ago, and I think what he's referring to is an undergraduate contract law essay. So, take heed, everybody. If you do a good job in your contract law essays, you might find yourself quoting your own essays in the Court of Appeal a few years later. So if I may quote from an essay which I wrote some years ago, says Lord Justice Mackinnon, I then said, prima facie that which in any contract is left to be implied and need not be expressed as something that so obvious that it would go without saying. So that if, while the parties were making the bargain, an officious bystander were to suggest some express provision for it in their agreement, they would testily suppress him with a common, "Oh, of course." So, this metaphor has been repeated right around the Commonwealth and all common law countries, which, the idea, imagine some officious bystander sort of walking along and he sees two people contracting and he says, would you have put that in your contract, or would you put this proposed term in the contract? Both of them look at it and they say, of course we would, now go away. So that's the officious bystander test. The problem is, like the business efficacy test and the presumed intentions of the parties, people often disagree about what it should actually mean when you get down to it, because contracting parties disagree. So what is the legal position today? Now, the leading case, although very controversial in its outcome, is called Equitable Life Assurance Society and Hyman. So this reflects the law now. This case was about some life insurance policies gone wrong. Equitable Life Assurance Society's directors had purported, under Article 65 of a contract with their policyholders, to use their discretion. That's what the contract said. They had discretion to reduce the premiums that were due to a certain group of life insurance policyholders called the guaranteed annuity rate policyholders. So what this is about is you get a life insurance policy which, is going to cover you in retirement, or if you die early or earlier than expected, it'll cover your family. And the guaranteed annuity rate policyholders were guaranteed a fixed sum of yearly payments, that's annuities, at a certain rate. They were guaranteed that despite what fluctuations in the stock markets might do with the money that their policy, that their insurance premiums had been invested in. So they were guaranteed a certain rate. Yeah. Now, on top of this, they've got a right to a premium on top of the guaranteed annuity rate, and the directors are varying the premium upon the guaranteed rate, and they're doing this because the company is in big financial trouble, and they've got these other policyholders called the current annuity rate policyholders, who have been hit by fluctuations in the markets, and their policy values have gone down. So the directors are saying, oh, well, we better reduce the premiums for the guaranteed annuity rate holders so that we can prop up the amount that the current annuity rate policyholders get, so that it's a bit more equal, because otherwise the current annuity rate policyholders are going to get very annoyed and probably sue us. So it's used its discretion to vary the premiums on the guaranteed annuity rate policyholders. And the question is whether that is okay. So the guaranteed annuity rate policyholders are saying it's not okay because we had a guaranteed contract and you can't just change our premiums. That defeats our reasonable expectations. We were guaranteed a certain sum of money. And the House of Lords held that they are right, that the discretion that was reserved in Article 65 to the directors of Equitable Life Assurance Society was not to be used in a way that defeated the reasonable expectations of the parties. According to Lord Steyn, we only imply terms into a contract as necessary, but we do so to reflect the parties' reasonable expectations. So here he is saying the following. It's an individualized term. The term may be imputed to the parties. It's not dependent, unlike the Moorcock, on proof of actual intention. We construe this out of the agreement in its commercial setting, following Lord Hoffman. The principle is used sparingly and cautiously and shouldn't be employed to imply a term in conflict with an express term of the text. And the legal test for the implication of the term is a standard of strict necessity. But it should be done, as I say back here, to reflect the parties' reasonable expectations. Necessary to reflect the reasonable expectations, not just necessary in the air, but to reflect their expectations. So this is really applying the language of Adam Smith back in the 1700s. And the same line is pretty much followed in a very important decision called Attorney General of Belize and Belize Telecom. So this was about the Attorney General claiming that it could remove Belize Telecom Limited's directors from the board, even though the company constitution said that the shareholders to remove two particular directors needed to hold two classes of shares at the same time. Now, I'm going to let you read the details on this because there's a little bit of reading to do, but essentially you've got different classes of shares, right? And these different classes of shares, when put together, can remove different directors. And in order to remove two of the directors, you needed to hold both what we called a special share and then at least 37.5 of the other share capital. Yeah. The problem was that because of a botched privatization deal, the government had repossessed shares of a company from the investors which hadn't paid them a loan, and they'd forgot to put in the drafting document, in the security agreement, that they would repossess both the special share and the other shares in order to dismiss these two directors. So after all of this went wrong and the buyer defaulted and the deal kind of collapsed, you had these two directors who were claiming that they couldn't be dismissed by anyone because the government, now the shareholder, had forgot to repossess the special share. So it comes to the Privy Council, and the question is, how should we interpret the company constitution? Could the directors, these two directors, be dismissed? Lord Hoffman, giving advice for the Privy Council, advises that despite the express terms of the company constitution, in particular in Article 90E, requiring that you need special shares and C shares to dismiss these two directors, you can dismiss them after all. He says the situation with which the articles do not expressly deal is where a change in shareholding results in the board no longer reflecting the appropriate shareholder interests, but without enabling this to be corrected by the exercise of power to remove the directors. So something's obviously going wrong, and this is undermining the balance of power on the board, which people reasonably expect. So he says it's true that Article 90E, if we read it expressly and literally, says that C directors, the ones subject to the C shares, shall hold office only subject to Article 111, 112, which means you've got to have two classes of shares at the same time. But that cannot, in the board's opinion, be construed, and this is the magic word, be construed as contradicting the proposed implied term, which is that you can remove the directors despite not having the two classes, to which the draftsman plainly did not address his mind. So what Lord Hoffman is doing here, in my view, is he's construing the express terms very narrowly in order to give way to an implied term which reflects the party's expectations, that you don't have directors holding jobs for life and that they can be dismissed. Lord Hoffman says the court has no power to improve upon the instrument which it's called to construe, whether that's a contract, a statute, or articles of association in a company. It cannot introduce terms to make them fairer or more reasonable. It's only concerned to discover what the contract means. But the implication of a term is not in addition to the instrument. It spells out what it means. But when we're talking about what a contract means, we're interpreting it. And I don't think Lord Hoffman said this very clearly, but I think that this is what he had in mind, that we're interpreting it according to the background of social expectations. Here's more from Lord Hoffman. Basically, he approves this idea of Lord Steyne, that the idea of implication of terms and construction is to give effect to the party's reasonable expectations. So this has been highly debated and still debated today, even after the Supreme Court judgment that we're going to see in a second called BNP Paribas and Marks and Spencer. So there's a few different views on Belize. One view is that Lord Hoffman should have just said that all contracts are based on good faith and fair dealing. All this stuff about looking for what the parties mean, is going a bit far. So this first view from Professor Hugh Collins is that we should just say that when terms are unfair, we should cancel them if it would be contrary to good faith and fair dealing. Professor Hugh Collins, by the way, is you'll find him in textbook extracts. So he works at London School of Economics. Then there's Richard Hooley, commercial lawyer, used to be at King's and now at Cambridge. So he writes in the Cambridge Law Journal that Belize is basically right, but also argues that the implied term wasn't ever contradicting the express term. So taking Lord Hoffman more at face value, and that the decision was basically correct. I think that there's a third position, and this is the one that I favour. I would argue that in Belize, it was obviously the case that the implied term did contradict the express term and that it was cut down, as I've said, to fit the implied term. And that this was necessary to ensure that the company's articles reflected the party's reasonable expectation. And crucially, that expectation in company law is that the board should be accountable to the members of the company, whether that's investors or any other stakeholder. And this is the same method as we've seen, contra proferendum, like in Pfeiffer and Deutsches Rotes Kreuz, and it's based upon the party's reasonable expectations. And I think that we're backed up in saying that that's what Lord Hoffman had in mind from what he later said when he left the Supreme Court, or when he left the House of Lords, rather, in this memorial note for Professor Ronald Dworkin, who's a famous legal philosopher. So Lord Hoffman explains his thinking here. when Ronald Dworkin published Law's Empire, which is a book about how judges should go about judging, it could not have come at a better time because I had just been appointed as a judge. It explained what scope I had for making choices and when I was constrained by the need for fidelity to the language of the statute or to the past or to the long history of the common law, and when I was free to choose a way forward. And to that we could add, not only statutes but also company articles and contracts. Lord Hoffman says, it explained how I thought I should make that choice by interpreting rules in a way that I thought was best calculated to promote the values of the society or British society in which I lived. I felt comfortable with that description of my role. It seemed a noble aspiration. The idea that we interpret things in light of the values, the social values that surround the context. And as I say, it's going to be different when we've got commercial agreements, employment contracts, consumer contracts, company articles, tenancy agreements. There's a background, I think, of social expectations. Now, this is controversial because, as you'll see in one of the more recent leading cases of the Supreme Court, a commercial decision, and that's very important to stress, this is a commercial decision, the Supreme Court kind of rolled back on some of the things that Lord Hoffman has said and believes, but not entirely and not by a majority. So in this case, Marks and Spencer had claimed that it should be reimbursed by its landlord, which was BNP Paribas Securities, when it terminated a lease early on a property in Paddington. So if you go down to Paddington Station around the Paddington Basin, there's all these flashy new buildings. And Marks and Spencer was claiming that it should be reimbursed the rent when it terminated a lease early. There was no term in the lease agreement that said what would happen if the right to terminate was exercised, if, as was the case here, rent had been paid in advance. So could they get the rent back? And, this was a significant sum of money because they're two big commercial organizations. The Supreme Court held that no implied term would be made or construed. It was not necessary to do so. And it stresses, Lord Neuberger in particular, that the test for implying terms is one of necessity. And I think that all of his comments start with the fact that this is a commercial contract. He reaffirms the Moorcock and Sherlaw and Southern Foundries, and the central part here is that you would consider a term to be implied if it would be so obvious as to go without saying or be necessary for business efficacy. And the language of business efficacy is particularly important here in commercial cases. And a term will be implied if it's essential to give effect to the reasonable expectations of the parties, but that should not be construed or held to mean that the test of necessity is diluted. As some people had argued, like Professor Collins after Belize. Now, Lord Clark and I think a majority of judges are keen to stress that many of Lord Hoffman's comments are still correct, particularly that the process of construction, implication and interpretation might not be the same, but all of this is one part of the process of construction about finding the objective meaning of the contract. So that's the quote there that you see from Lord Clark. Now, I'm very conscious that we've just come up to 2 o'clock, but if it's okay with you, I'm just going to take you for 5 more minutes to just finish off the slides, and then we will be done. And we're just going to talk about 1 or 2 more important things before I conclude. First of all, and I mentioned this at the start, but I think I just have to come back to it. This isn't very important for contract law, but as I say, the question of implication also does come up in statutes, and we see some important guidance in a case that involved the ex-president of the United States, the orange guy, and there he is depicted in real life with little hands. Involving Trump International Golf Club, Scotland Limited, and Scotland. And in this case, Donald Trump tried to claim that Scottish ministers were unable to give consent for a wind farm outside of his golf course on the coast of Scotland, arguing that it was a necessary implication in the Electricity Act that you could only get a permit for a wind farm if you already had a permit. And the basic point of this is that the Supreme Court holds that Trump of course, is a loser and that he doesn't get anywhere. And of course, there he has his loser face on. Very, very sad. There's also a case about Ukraine. Of course, this is about Trump's former employer because it involves Vladimir Putin and Russia, but you can read about that more in your spare time. But now, the serious point that I just want to finish off with is about good faith. Because there is a debate about whether or not good faith should be an implied term or an organizing principle for the whole of contract law. Should it be the basis for all implied terms or something more narrow? Or to what extent is it a part of English law? The case that started off this debate again in the UK is called Yamseng and International Trade Corporation Limited. Yamseng was International Trade Corporation's exclusive distributor of Manchester United fragrances in the Middle East, Africa, Asia, and Australia. So Manchester United, of course, is the football team, and I'm not sure what the perfumes or fragrances are meant to smell like, but apparently there's a market for these things. To smell like Manchester United. But anyway, the problem in the case is that ITC had told Yamseng that retail prices were being put up elsewhere to $65 when actually that wasn't true. And that's important for Yamseng because the fragrances are being sold elsewhere for a lower price, then that can enable parallel imports, and it doesn't want its business to be undermined on that ground. So Yamseng claims that ITC has breached an implied term of good faith, that it has undermined their contractual dealings. And Justice Leggett, who is now, I think he might even be on the Supreme Court, he's definitely on the Court of Appeal, he might have gone up to the Supreme Court, holds that this breached an individualized implied term of good faith. Good faith can be implied into the agreement, and that's particularly important, he says, in relational contracts. And what Justice Leggett means by good faith here is at the very least a core obligation of honesty, important in long-term contracts. Not the standardized implied term, but appropriate for the particular facts in order to fulfill the parties' expectations. Now, that is a much narrower meaning, the core idea of good faith being reduced to honesty, more narrow meaning than we find in other cases. I'm just going to skip over these ones. In Carter and Bone, back in the 1700s, Lord Mansfield, one of the most famous commercial judges, important judges in history, argues that good faith should be a part of all of the law of contract, but it got confined to insurance cases in English law. However, the Canadian Supreme Court, again, doing a very, very progressive judgment in Barzan and Harainu, says that good faith should be an organizing principle and a mandatory term that you can't contract out of for all kinds of contracts. And essentially, in this case, it was about an enrollment director who's got a job for a company, and he says that good faith is being breached by a lack of fair and open dealing between the parties. The Canadian Supreme Court says that this should be a mandatory part of all contractual relations. So we have a very good question about whether the same thing should be true in UK law. Okay, so I'm just going to wrap up right now with these conclusions and a summary of the argument. The first point is that I would argue that Adam Smith and everyone following him up to Lord Denning, their ideas were good ones, that contracts are and should be rooted in the reasonable expectations that people have. This isn't exactly the same as good faith, but it can perform very, very similar functions. Different language, but very, very similar functions, and established in UK law. The second main point is that Lord Hoffman, I think, was right in ICS and West Bromwich, and also Belize, that contextual construction is the best way to approach construction, but arguably he should have gone further, as he later spelt out in his lectures, and anchored his views on the process of construction in the social expectations or the values that people have, and ultimately that it should include rights. And thirdly, my last point is that what we say about implied terms matters. reason why this discussion is so important is that before we get to statute, this shapes our perception as common lawyers. So if we say that there's just unrestricted freedom of contract without any duties based on people's values and people's sense of justice, then we end up letting contractual power and discretion be abused in a way that advantages the strong and oppresses the weak. So what the law should do instead is uphold rights rather than saying that anything goes. Okay, so that's the end of the lecture for today.